For the record, my name is Mark Burke. My P number is 54935. I'm with the Attorney General's Office appearing for the people.
Good morning, Your Honor. Lauren Madison from Harris Law on behalf of Frank Dion, who is standing to my right.
This is the date and time set for imposition of a delay of sentence. And there was a report prepared. And Ms. Madison, did you have an opportunity to go through that with your client?
Yes, Your Honor.
Are there any corrections that need to be made to that at this time?
Just briefly, Your Honor, there was an indication on the report that Mr. Dion does not make upwards of $75 per week. He does own his own carpentry business and brings in about $600.
Okay, Mr. Burke, any objection to that correction?
No objection, Your Honor. Thank you.
Any other corrections, Ms. Madison?
No, Your Honor. Last time we were here, we were discussing the issue of whether, in fact, Mr. Dion had successfully completed drug treatment here in Otsego County. It is his, I believe, sincere belief that completion of that program was supposed to have led to a reduction of that prior felony to a high court misdemeanor. I've been able to find no documentation regarding that. Again, I believe that that was his sincere understanding. We don't have any proof that that is in fact what was entered into or that that was what even was offered. I suppose moving forward, I would just ask the court to take his understanding into consideration in rendering a sentence.
Well, I appreciate the suggestion, but I can't really do that. I mean, there isn't any record of it. I can't take someone's subjective belief about what they thought as any kind of basis. So
I suppose I would ask more that the court give weight to his successful completion of the drug treatment program, which is verified in his PSI.
yeah, I mean, anything that's verified, I certainly give appropriate weight to. Okay, Mr. Burke, was there any corrections that you needed to make?
Your Honor, to be honest with you, I received the PSI report from the Lansing office, but in a format that I couldn't open or read. So I haven't really actually seen the report. I presume it's fine. I don't even know what the guidelines are. But the one thing I will indicate, and I just want to make sure that we're clear on this. When we were here last time back, I think on January 20th, the defendant took a plea to counts 1, 2, and 3, and the HAB second was kind of put on hold. And I think he needs to plead to the HAB second today. But again, with the understanding that the people are recommending a delayed sentence, and that's what we're still recommending. The defendant did make another payment of $600 in January, which is great. He's making payments. That's what we like to see. That's fantastic. He's making some great progress. So I want to make sure that that's all indicated on the record and to proceed accordingly. I can also give the court an update as far as what the current arrearage is, as well as the defendant's current support obligation, if the court would like those numbers. So that being said, the people are ready to proceed with the delayed sentencing.
All right, so Ms. Madison, it sounds like there isn't any basis to contest that that this is not a habitual second.
We have no verified reason to contest that, Mr. Honor.
All right, so the court is going to rely on the court records, which do reflect that the habitual second would be an appropriate enhancement. So I think we've got that part of it taken care of. In terms of, and typically for both counsel, I wouldn't address guidelines challenges at this time because this is a delay of sentence. So if there's some reason that we're back for an actual sentencing hearing, then we would address any guidelines challenges. So with that, Mr. Burke, was there anything else that you wanted to state for allocution other than what you've already stated for the record?
Nothing. Well, just a couple of things, I guess. The current arrearage that I have as of February 12th is $35,336.03, $35,336.03. The defense current support obligation continues to be $521 per month. And the only thing I would ask, I guess, is if the defendant, if Your Honor could, I guess, ask the defendant about the HAB second, the prior conviction in 2016. I don't know if the court's satisfied with that or not. If the court's satisfied, that's part of the plea, then the people are satisfied. I think normally the court would ask, sir, is it true that in 2016 you were convicted of whatever? I just wasn't sure if the court wanted to go that route at this time. So
yeah, I think given the way that we've addressed it for the record, my view is I put the burden on the defendant the last time to come
Okay.
forward with some kind of documentation that in fact he hasn't been convicted of prior felonies and he's failed to do that. So at this point, I'm going to accept what the court records are, which do reflect those prior convictions.
Okay.
So that's how I'm viewing it.
That sounds great, Your Honor. That's fine with the people then. Thank you.
Okay. Ms. Madison, anything that you wanted to state for the record today?
Just briefly, Your Honor, I would ask the court to take into consideration Mr. Dion's successful path that he's been on. I understand we're here before the court on felony charges today. I would ask the court to, in rendering its sentence, and forgive me, I guess procedurally, is it the court's practice to render a sentence that would later be he would actually do later, or like will you give a sentence that he will have to complete today, or that he will have to complete down the road if he doesn't bring the arrearages down? Or is today more about, are we going to enter into this delay?
Sure, fair question. So the way that I address delays is at this hearing, I would state all the conditions of the delay, which would include, of course, paying the child support as contemplated under the plea agreement. If for some reason those conditions aren't complied with at any point during the next 12 months, then the court would set this for a sentencing hearing, at which time I would impose a sentence. So I don't give a conditional sentence on the record today. If it's not completed, then we go forward.
Okay.
We would come back, we would have a sentencing hearing. All parties would be able to once again address any issues with the PSI. Each side would have an opportunity to address any challenges to the scoring guidelines, and then the court would impose an actual sentence at that time.
Okay, thank you for that clarification. I will keep it very brief then. Mr. Dion is an owner of his own business. He's working. He understands the importance of getting those payments done and reducing the arrearages to the greatest extent he can. He's been clean and sober for nearly 10 years. So we would just ask that the conditions of the delay be minimal at this time, Your Honor.
Thank you. Mr. Dion, anything you wanted to say here today?
Your Honor,
Okay, so
pardon me, I
I'm
apologize.
Sure, go ahead.
I'm so sorry. I just got an email from the Lansing office with a PSI that I can actually open and read, which is great. So I just wanted to make one clarification. In the PSI that I'm looking at, it shows the on CFJ 145, page 1. It shows the three counts, 1, 2, and 3. It says maximum, says 4 years, but with the HAP second, I think it's going to be 6 years. I just want to make sure that the record was clear on that. But we're not, naturally, we're still asking for delayed sentence, of course. So because the defendant's great payment history. So
Ms. Madison, any objection to that?
No objection.
I believe that's an accurate correction.
thank you so much, Your Honor.
Yes, thank you for that correction. All right, so Mr. Dion, again, I'm well familiar. It's been a long road to get to this point in terms of the pendency of this case. I think this is an appropriate resolution. I generally think it is in most of these types of cases. Again, the goal here for everybody is to get these amounts paid. And I think this sets you up for the potential of success in doing that. It sounds like you've already been making diligent and good faith efforts to do that so far. So I hope that you'll continue with that over the period of this year. The court is going to adopt as the conditions of the delay all the terms and conditions in this report. The delay will be 12 months. The court is also going to order, as it's required to do, a crime victims assessment of $130, court cost of $325, a state cost of $204, and a supervision fee of $30 per month during the delay. The court, because, and I do this in all of these types of cases where, again, the focus is on having the child support paid. The court would consider other methods like community service instead of the court cost. So that $325 is something that I could waive in lieu of, a community service or something like that. Unfortunately, the other fees are mandatorily required to assess those. But I'd rather have that $325 again go towards the child support if you would rather do community service instead of that. So I certainly would allow that. Because this is a delay, the court isn't going to impose any jail time at this time or any jail credit. There are also no appellate rights. But Mr. Dion, it's just important that you meet. And is Mr. Brunical going to be in touch with him?
I instructed him to contact Agent Brunical.
Okay, so just make sure that you contact Mr. Brunical to follow up after today's hearing. And I'm hopeful that we'll be back in 12 months with a successful delay and discharge you at that time. Ms. Madison, anything further for the record here today?
No, Your Honor. Thank you.
Mr. Burke, anything further from your side?
The only question I have, Your Honor, is with respect to the delayed sentence review hearing, which would be the actual sentencing in 12 months or 11 months or so. I presume the court will schedule that hearing and just notice it out to the parties and attorneys?
Correct. Yep. We'll provide notice of the day and time of that hearing, probably 30 days prior to it.
That sounds great, Your Honor. Thank you so much.
Okay. Thank you, Mr. Burke. You're free to disconnect. Mr. Dion, good luck to you.
Thank you very much.
Able to hear me okay?
Yes, Your Honor.
All right, we'll go on the record. This is file number 256920, People versus Demick. Mr. Demick's appearing today by Zoom by prior approval of the court. If I could have counsel put your appearances on.
The record, Your Honor, Mike Ronald, behalf of the people.
Thank you, Your Honor. Richard Church, appearing on behalf of Mr. Demick.
Trish, can you tell me the status of this file? I know that you were appointed on this one fairly recently.
I have been, Your Honor. I was just recently appointed. However, from the notice, I could see that it's been adjourned quite a few times leading up to this. I know at least a couple of them were while Mr. Demick was trying to get screened for appointed counsel. There were some issues that occurred with that process. We're not ready to proceed in a meaningful way today. We're going to be asking for one more adjournment on this. I would indicate, though, we have hit the ground running on this. There's a little bit of investigation that I need to do. However, I've got all the information from Mr. Demick that I need to be able to push that forward. At the same time, Mr. Demick is in the process of exploring the possibility of a veterans treatment court in his home county. As the court knows, the process for a transfer and all that with that can be a little complicated. So again, I know that he's already hit the ground running and made, I got the information to him about the courts. I think he's made the initial contacts with several courts that are geographically in his area. Oakland County has quite a few of them that he may be able to avail himself of. So again, we've kind of hit the ground running, but we're not quite there. Additionally, I am in receipt of an offer from the prosecutor. I do have a counter proposal for him, but again, frankly, I haven't had an opportunity to discuss it with him yet.
Okay. Mr. Rolla?
Yes, Your Honor. We offered to pay to counts 1 and 2 $200 reimbursement to the Sheriff's Department for the blood testing. That's the offer of the people. It would be then dismissal of the other 2 counts.
Okay. So I guess Mr. Trush and Mr. Demick, what I would say is this case was bound over, so it's been in my court since October. So we're looking at quite a bit of time where there hasn't been much happening. And so I don't have an issue adjourning today. But to the extent that, a treatment court is going to be part of a resolution here, that's going to need to happen quickly. And, frankly, this case has been pending. It was bound over in October, but it's been pending since I think March of last year, so almost a year. So there's been more than enough time for treatment courts to be investigated and all of that to happen. And Mr. Demick had retained counsel up until this point. So I'm just not going to allow any further delays for the purpose of treatment courts. Those are, again, that's something that could have been investigated and set up. Well,
Your Honor, could I, my last lawyer.
Eugene, I don't think we need to go down that road. It sounds like the court is going to give us the adjournment that we requested. I think it is in our best interest to say nothing further on that issue.
And frankly, it doesn't matter the reasons. There's been a lot, this case has been pending for almost a year, and there needs to be a resolution one way or the other. The court is going to grant that adjournment. I just want to make sure that everybody's clear that the court isn't, I'm just not in a position to allow any further delays. So that's where we're at.
Understood, Your Honor. And again, I recognize when I got the file some of that history, and we're not wasting the time.
Okay. All right. So we'll set this for a status conference plea hearing. Mr. Demick, it's important that you continue to remain in contact with your attorney so that we can get things moving. And did you have any questions, Mr. Demick?
Just the last thing was about changing my address, because I've been currently living in Oxford, and I don't know if that's something I need to put on the record as far as where, because right now I'm getting the mail's going to my house. My son's living there, so I'm getting the mail sent to me.
What's the address you have? What town?
I have Gifford. It's not Oxford.
Okay, we currently have a Gibraltar address. Did you want that changed?
Yes, Your Honor.
Okay. I'm not going to have you state that on the record here today because we're broadcasting this hearing. So just let Mr. Trush know, and Mr. Trush, we can communicate with the clerk's office and make sure that they have that Oxford address.
Yeah. Gene, just email that to me and I'll get to the court, okay?
Okay, thank you.
All right, thank you. Mr. Demick, you're free to disconnect at this time.
All right, thank you, Your Honor.
People versus Cornett, file number 256943.
The record, Your Honor, myself, that people.
Thank you, Your Honor. Richard Trush appearing on behalf of Ms. Cornett.
Record should reflect Ms. Cornett's present here in the courtroom today. Mr. Trush and Mr. Roll, I was informed by my court officer that there was a distinct odor of alcohol on Ms. Cornett this morning. So I'm going to have Ms. Cornett sit here in the jury box. We're going to administer a PBT. I want to make sure that she hasn't been drinking and that she's in a position that she can meaningfully participate in the hearing this morning. So we're just going to take a break while we do that, and then we'll come back on the record in just a minute.
All rise.
All right, we're back on the record. Ms. Cornett, you did test positive for alcohol this morning. You're not above the legal limit, but it's high enough that I'm not going to proceed with the hearing today until you're sober. So I am going to revoke your bond. We're going to take you into custody, and then we'll reset this for a sentencing hearing at a later date. In the interest of being prudent and making sure that we don't have any appealable issues later, I just want to make sure, now that I know she's under the influence of alcohol, that we only proceed with this hearing while she's sober. Mr. Trush, any record that you wanted to make on
that? I mean, can the court indicate to me what the level was?
0.04.
I would just indicate to the court, she indicates to me that she has not consumed any alcohol today. I have no additional information for the court. I would suggest to the court, I am available all day if the court wants to address it.
I court railing this afternoon, so we'll have to reset it for a different day. And we have a record of her saying she's not or hasn't drank, but at a 0.04. It is what it is. Test doesn't lie.
I think all this information is new to me.
Yeah, and that's fair. And I want to indicate for the record that Ms. Cornett also apparently was under the influence when she appeared for her interview for the PSI. And then, of course, she was under the influence at the time she was arrested for this offense. So, frankly, the positive test here this morning is kind of in line with what's been going on anyway. So that gives me further reason not to doubt the results or think it's from something other than alcohol. Mr. Rolla, any record that you wanted to make? No, okay, all right, so for the and I'll issue an order, written order on this too, but Ms. Burnett's bond is revoked for using alcohol during the time of bond for appearing here in court under the influence of alcohol. She'll be held in the Otsego County Jail until we can get this matter reset for sentencing, and we'll notify all parties of the date and time of that hearing. Our next hearing is set for 10:45, so we'll be in recess until that time.